Let's begin. Firstly, I'd like to thank all of you for being here after a long day of classes, and Mr. Garv Malhotra for coming down on a weekday to be with us today and conduct this workshop. It's not very often that we get opportunities to expand our horizons beyond the textbooks over here, and this initiative, the workshop, was an effort to sort of alleviate that something that was missing. And I'll let Mr. Malhotra introduce himself before he begins. And without further ado, I welcome him.
Am I audible to everyone? Thanks, Siddharth, and thank you everyone for coming. My name is Garv Malhotra, and it is my absolute pleasure that I'm here. I must thank Nyaya Initiative for organizing this and inviting me here, and to all of you for hosting me as well as for turning up after such a long day. I also realize it's your fest week, so the vibe in the air must be very different. I will try to keep up with it. I'm very humbled in the realization that some of the people who have addressed you here before me have been some of the most prolific and distinguished counsels and judges and arbitrators. So I, as a mere mortal, I wonder what I can add. Also, I realize I went to GNLU, so all of you are probably smarter than I am. So what I'm going to add here today is a freshness of perspective. I'm going to share with you observations and experiences that I had in various jurisdictions, Paris, Geneva, Hague, Singapore, London, as well as a lot of things that I wish somebody told me when I was graduating from law school. Because, believe it or not, this is a paid holiday. The moment you graduate from law school, reality will hit you like a brick bat in the face with full swing. And you will realize that practice of law is very different from studying law. Because here they teach you the law, but they don't teach you how to use it to get the relief that your client seeks. Although this session is primarily aimed at arbitration advocacy, a lot of things we discuss here can be adapted to courtroom advocacy or even mooting. Okay. I realize we have some exceptional mooters here. This is Nalsar, very famous for its mooting culture. So anybody who wants to share an experience, an insight, discuss something, please interrupt and butt in. We will start off with generally discussing advocacy and arbitration advocacy, how courtroom advocacy is different from arbitration advocacy. We'll discuss some of the stupid things we counsels do, and I include myself in it. I may have done that at some time. I would have observed some counsels do it, as well as some smart things we do and some things you should try to imbibe in your own practice before we zoom into oral and written advocacy. Okay. Again, some housekeeping things. I have some rules of this class. My name is Garv, not sir, so you address me that way. Your name is, I don't know, so when you start off, please introduce your name as well as which year are you in. Again, you have all your freedom in this class. If you want to eat something, go ahead, drink something. Just don't do it loudly. You want to talk to each other, text silently. It's fine. You can keep your phones on the table. You don't need to hide them. And you can walk in and walk out of this class at any time you feel like. You want to get a cup of tea or you just want to walk out. I won't remember you. So feel free. I am not going to get offended. Okay. And the last rule, please interrupt me. Okay. Anything that is unclear, any insight you want to share, anything that's on your mind, please interrupt me. So let's jump straight in. Advocacy as the note sent to you must have said, is the art of persuasion. Now, this sounds fancy, but it's not just in the courtroom or in an arbitration chamber. It could be to your professor to give you some extra attendance, or to anybody, to a friend, to your girlfriend. Whenever you're persuading somebody, it's advocacy. Now, the art of advocacy lies in the small things. It lies just as much in general pleasantries, the unexpected washroom conversations, the curtsies and the commas. And there is no straitjacket way. Like, I cannot teach you advocacy here. It cannot be taught by its very nature. You observe it, you make your own observations, you see it, you emulate it. But the problem with arbitration advocacy is that it is much harder to learn than courtroom advocacy. And the reason simply is that you can't walk into an arbitration hearing room, sit and observe. Something you can do in a courtroom. So the best practices of arbitration are generally confined to the four walls of an arbitration hearing room. But there are fundamental differences between arbitration and courtroom advocacy. A lot of people think that arbitration is courtroom in a hotel. That is not completely accurate. Now, before I jump further, I realize that there may be some first years and second years in the crowd. So, just by a quick show of hands, can you tell me how many first years are there in this crowd? Alright, a fair few. Second years? Alright, so I'm guessing that you haven't really been introduced much to arbitration. But I'm still being generous to myself in assuming that you have a small idea of what arbitration is. But I will very quickly tell you what arbitration is. It is an alternative dispute settlement mechanism, an alternative to traditional courtroom. Now you must be thinking, this is Nyaya Forum for Courtroom Advocacy. What am I doing here? But I'm here to pitch to you, to tell you how arbitration, being a different form, has a different style of persuasion than the courtroom advocacy you may have seen in your internships. I won't count movies, but a lot of people do make their perception from movies. In arbitration, you choose your own judges, who are called the arbitrators. Again, what is your name, sir? Kushal. So if Kushal and I have a dispute, we both have let's say we agree to arbitrate our dispute. He appoints one arbitrator, I appoint the second arbitrator. Both of our arbitrators appoint a third arbitrator, and they adjudicate the dispute. We argue our case in front of them as if it was almost like it was done in a courtroom. Again, everything can be caveated with depends. This is generally how the procedure looks. It could be very different depending on a lot of factors. But again, you choose your own decision makers. Second, there is only one level of adjudication. There is no court of first instance, appeal, second appeal, special appeals. It's a one-stop shop for all the factual and legal arguments that you can make. Third, you choose your own procedural and substantive laws. Now, if you go to court, you can't really avoid the civil procedure code or the laws that would be applicable to you. But in arbitration, you can choose beforehand that you and I have a dispute. We want English law to govern our dispute, or we want Swiss law or French law or the laws of New York. Again, it's party autonomy to choose whatever law you want applicable to it. Globally, arbitration is considered by the rule of the thumb default mechanism for resolving disputes. And one of the biggest reasons is that it is ideally much faster and therefore consequently cheaper. Arbitrations generally take 1 to 2 years, generally. And in India, we realize how long courtroom litigation could take. It could take decades. Therefore, arbitration has become the preferred means of dispute settlement. Arbitration is very fact-centric. So it's not like if you've gone to the Supreme Court, you'll realize that a lot of time we counsels spend only on a pure question of law. But arbitration, although you do agitate your legal points, but it is pivoted around facts. And the system is not designed for you. It's designed for the client, for it to be very easy for the client. Again, before I quickly move on, inside the arbitration chamber, how does a typical arbitration chamber look? You have the arbitrators on one side. Let's assume arbitrators are here. On the left flank and the right flank, you'll have the claimant and the respondent counsels. And opposite to the arbitrator, you'll have the witnesses. So generally, when the counsel are sitting and arguing, you are looking at the arbitrators diagonally. Now, if you noticed, you are sitting. Everybody in an arbitration generally sits. There's no standing advocacy. And there is a major difference between standing advocacy and advocacy sitting down. Seated advocacy requires much more eye contact and a much more restrained and intimate style of address. It's very different from the combative courtroom advocacy that you often come across. That is not very suitable for arbitration. Another difference is in the realization that everybody has that the arbitrators are being paid to do a job. Unlike in courtroom where the salaries of the arbitrators are paid by the state and you agitate your matter, you pay a court fees, but that's not necessarily the salary of the arbitrator. In arbitration, you are paying the arbitrators generally by the hour or by the day for their time to resolve your dispute. So it is much more business-like. The formalities are much less. One of the reasons I decided to take this session is the number of times in a recent arbitration I heard, Mr. Counsel, this is not a courtroom. And believe it or not, especially with Indian counsels, we hear this a lot. And this is so much more true when we are faced with an international arbitration tribunal. Because the things you are used to in a courtroom are very different from an arbitration. Arbitrations generally happen in hotel rooms or convention centers or arbitration hearing rooms, where you will find yourself suddenly in the washroom next to your arbitrator, and you have to manage that situation with the least possible awkwardness for everyone. This happens, and this will happen multiple times. Also, the breathing space you have to strategize between hearings in a courtroom. For example, you had a hearing today, went on for 15 minutes. Next hearing is 2 weeks later, 1 month later. You still have a lot of breathing space to re-strategize, to do your further research. This is something you don't have in arbitration, because a hearing will go on for even about 7 days at a stretch, from morning to night. And the judge or the arbitrator will be hearing only your case throughout those 7 days. That makes a big difference. He doesn't have so many other cases on his roster and doesn't have to constantly think about that. And this would make a major difference even in your written advocacy, because given the fact that they're dealing with only one case, they are more inclined to read it completely. And you have to understand, it is not humanly possible for a judge to read 150 special leave petitions before the Supreme Court every day from cover to cover. So they also do selective reading. But in an arbitration, when for the next 7 days you have one matter, it is more often than not that the arbitrators read the whole briefs. But again, you can't assume this. Also, in arbitration, it is possible for counsels to agree on a number of procedural issues. Something that you can't do in courtroom. You don't like this rule of procedure, you and I cannot agree to opt out of some mandatory rules of the CPC. even if we agree and tell the judge, both of us have agreed. But in arbitration, you could do that because it's a contractual system. Everything depends on your contract. So you should, even before the arbitration starts, try to agree with the other side on a number of things. Now, this can help you streamline the process as well as help you understand the other side's strategy. Do they plan to drag it out? Do they plan to quickly settle this? Is their objective to quickly resolve this dispute? And that would depend on how many procedural hurdles they want. Again, we've talked about that arbitrations are not as formalistic as courtroom. But now, realize that at the end of the day, they're humans sitting as arbitrators. You can think of them as chairs, but they do not have a rational, logical thinking similar to that of a computer, but that of a human being. I recently did an arbitration in which there was a retired judge of the Supreme Court on the bench, and it was a foreign international counsel, senior counsel in a different jurisdiction who was arguing. And he kept addressing the arbitrator as judge. But judge, I don't agree with this line of reasoning. Now, think for a second. Although that person may have been a judge all his life, he's more used to being addressed as my lord, your honor, your excellency, never as judge. Even though that may or may not be right from a neutral perspective, your job is to win the case. You address the judge as judge. For the next 2 minutes, he's just going to think about how rude this counsel is. He's lost what you said immediately after judge. So your real objection, even if it may have merit, would have been lost. And this brings me to the point that arbitration is a confluence of everything you know about law and cultures. It's not one law. And arbitration is not bound by national boundaries. You have so many cultures in arbitration that it's very often that you have an Indian party against a Taiwanese party with a Singaporean, an Australian, a British on the bench, and represented by a Swiss and an American seated in Paris, so all your support staff is French. Can you imagine how much get lost in translation? Okay, I'll share this anecdote. This was shared by my former mentor, Dr. Michael Wang, in his article, The Art of Advocacy. And he says, in one case, there was a witness cross-examination going on, and the chairman of this corporation, in relation to a very contentious decision he had made, was asked, do you agree that your decision was arbitrary? To everybody's surprise, he said yes. And when further inquiries was done, it was found out that the translator had translated the question as, do you agree that you made an arbitration decision? Which he further interpreted as, do you think your decision was made as an arbitrator of the dispute? So a lot of things are lost in translation. You cannot completely avoid them. But if you are mindful of this, you can pace yourself accordingly. You can avoid a few common mistakes. Again, I was seeing this transcription of an arbitration. This was not in the arbitration. This was a much later enforcement stage. But the transcript, when I read it, I wasn't sure what it said, because it said, therefore, he put his employees on fire without gratitude. I asked the counsel and he said, oh, no, I had said, therefore, he fired his employees without gratuity. This is something that is very common in international arbitrations. A lot of it gets lost in translation. One of the primary reasons is because there is pressure of short timelines in international arbitration. So the arbitrator will set a timeline. The counsel will try to get around that timeline by speaking twice as fast. The translator will translate 1 in 2 words. And the transcription will finally get 1 in 3 words or so. By the end of it, you can't make any sense of what's going on. So pacing yourself while arguing is very important. Now, in international moots, we face this a lot as Indian mooters, as in international arbitrations, as Indian counsel, that English is like our native language. We speak it so fast that people don't understand. And it's surprising how much of our points just get lost because we spoke so fast. By the time the arbitrator caught up and understood, absorbed what we really said, we are already 3 sentences down. Which is my segue into the stupid things we do as counsels. Okay. Now, there are many, much more than I can count, much more than I realize myself. Maybe 5 years later, if I'm doing this again, I will have so many more insights to share. But again, a lot of things that I observed and I saw, I read about, I share with you here today. First, winning your case is not just convincing your tribunal that you are right. It's about engaging with the other side's argument. Now, this is something a lot of mooters forget. A lot of counsels in international arbitration really forget about it. That it's not, I have a beautiful point, I have a wonderful legal interpretation to give, but I'm totally skirting what my opponent is arguing. So the arbitrator isn't really going to give you marks on your mooting scale that, okay, points for poise, points for content. It's not going to work like that. And neither is your client going to care. All your client cares is whether you got the relief at the end. So engage with the other side's argument. Do not ignore it. Sense the tribunal's concerns. There'll be a very good counsel will constantly keep reading the tribunal, and that is an art. It takes experience to practice and master, but you keep reading and sensing the concerns of the tribunal. Even before they raise it, preempt it and go ahead. Respect the intelligence of your arbitrators. Don't go to the arbitrator and in a hearing say, this is a contract. It defines the rights and obligations of the parties towards each other. You say this, the arbitrator thinks you're schooling them. There are so many things that we knowingly or unknowingly do that really irritate and annoy arbitrators. And if your arbitrator is annoyed, be sure you're getting the shorter end of the stick. Your arbitrator is not just going to look at how you conduct yourself towards the arbitrator, but also towards your opposite counsel. Now, in courtroom advocacy, there is a tendency to be very caustic to the other side. This is certainly never appreciated in arbitration. Everybody is there doing a job. There is much less scope for passionate arguments and aggressive argumentation as is there in a courtroom. And even if your other side is being caustic, let things slide. The tribunal will notice it. You have to build trust with the tribunal and your credibility. Be likable. Reason for this is we believe good men more fully and readily than others. Aristotle. Somebody you like, you are just more inclined to believe them. We always think, okay, judges, for 20 years experience in judging, they must have now become so detached and dispassionate about decision making. But that is not true. They're humans. They do get swayed by emotion, by other factors which are beyond, they are not mathematical. A lot of you may have heard this. Your order is what the judge had for breakfast. This is a reality. Arbitrators, just like judges, they do get a little grumpy, so to say, right before lunch, and a little sleepy after lunch. But that's human, don't you get? We all do. So, step by step, during your whole arbitration, you build trust and credibility with your arbitrators. And you lose trust by conveying false information. And not just deliberately. Because more often than not, it is conveyed carelessly. And still trust is lost in the process. So this is something you should be very careful of. Again, a few things I'm telling here are more like do's and don'ts, the stupid things, the good things. But you don't oversell your case. Even if there is a small possibility, never say that there is no shred of evidence. Something like this, a categorical statement like this, is often taken as a challenge, knowingly or unknowingly, both by our opposite counsel and by the arbitrator. Again, another thing, in international arbitration, please avoid using cricket, golf and baseball analogies. Like, I saw an English QC once make a beautiful analogy. Like, I heard that analogy and I said, wow, what an analogy. Again, you won't understand it completely because without the facts of the case, but briefly his analogy was that although the ball was outside the rope when I caught it, my feet were firmly planted inside the rope. So it's a catch, not a six. Wow, beautiful analogy. But to a tribunal of a Swiss, a German and a Singaporean, it made no sense. Which will be very often. So understand that very few people play cricket. Baseball, cricket, golf, a lot of these sporting analogies, be very careful before you use them. You could use them if you know that the tribunal is a big fan of that sport. Okay, I will come to that point a little later. Again, acronyms and fancy flamboyant words. If you use a word that the judge has to look up, and realize most of them don't really pull out their smartphones and Google. They take out a dictionary and look up a word. If you use a word in your pleadings that the judge has to look up, you've already annoyed him. So it's not a test of how fancy language you can write, but how simply you can convey your point and convince them. Again, PowerPoint presentations. Now recently, people have started using PowerPoint presentations a lot. The reality is they aren't as helpful as people think they are. We saw an arbitration in which it was an energy arbitration. So there was a technical point to be explained. The claimants had made a very fancy animation going on for like 5-6 minutes, and it was almost like a Pixar movie. After lunch, they switched on the animation, dimmed the lights. 6 minutes later, when they switched on the lights, 2 of the arbitrators had fallen asleep. And this is a reality. Now, understand that the arbitrator would be looking at the documents in front of him. So in all probability, he would have his reading glasses on. He's going to be very often too embarrassed to pull out his distance glasses and look at your PowerPoint presentation. Even if he can, he's looking at it with a lot of difficulty and probably making out what you're writing, but he's still not sure. So it doesn't really do you much good. In fact, in that process, you lose the real points that you're making. So avoid PowerPoint. Unless, for example, you are showing pictures of the site. Or if there is one single clause that your whole case revolves around, I would prefer to put it up there and leave it there and forget about it. Whenever the arbitrator wants, instead of flipping to that clause in the contract, he can just look up. But they're not as useful as you think they are. Yeah, please.
Don't you think that the situation could possibly change with a lot more young professionals being appointed as arbitrators? Because there is a movement to sort of get younger arbitrators on board. And so would possibly 5 years down the line, if this sort of gains traction, would it not be possible that a PowerPoint may be more beneficial?
It could. I totally agree with you. But The ifs and buts in this are too huge. The fact is, there is a movement amongst the younger crowd for younger people to be appointed as arbitrator, but they are not the ones running the show. It's going to be, and I hate to break this out to you, myself, to everybody, that it's going to be a long, long time before young arbitrators, and young as we call them, being in our 20s, young arbitrators are appointed to the tribunals. Even internationally, that is not the practice. It is highly uncommon for people in their 20s and 30s to be appointed as arbitrators. And even the ones who are the most exceptional and distinguished people who are appointed somewhere in their late 30s. So, yes, this could change, but in India, with the trend of appointing judges, and even when that changes, it's not going to be that suddenly we shift from judges to law school grads. The transition would take a long time to come to what we call as young practitioners. Yes.
You stated that this is more or less a strict no-no, the idea of animations, videos, PowerPoints and such. That just got me thinking about how to make a very strong and emphatic opening statement. And as far as I understand, there are firms that do sometimes resort to videos and animations. And don't you think this ties in very well with your point about how it's important to read the tribunal? Because, for instance, if I were to have Gary Bond on my tribunal, if I were to make a Game of Thrones based video, then that would sit well with you. So isn't it important to, at the first instance, see what your tribunal is like, whether something like this, a gamble like this could pay off? Because if it could pay off, then it would be truly great.
Absolutely. I couldn't agree more. So everything I say here today can be caveated with a depends. It depends on who your tribunal is. If you know that they are avid fans of Star Wars or Game of Thrones, you should use analogies like that. But again, I based my presentation on theories of large numbers. Most cases, this is not going to work. In some exceptional cases, it'll work, and it'll work fantastically. You're a great counsel if you can see that and use it to your advantage. So you should, if you are absolutely sure. It would be a judgment call at that time, and it could go either way. But given the current situation, in reality, out of law school, most of the times it won't work. Do we have any other thoughts before we head out? Okay. Bad arguments. A lot of us have a tendency to hold on to bad arguments. When I was in Geneva, I tried learning sailing for some time. And the first thing they teach you when you learn to sail is that don't hang on too long. If you hang on too long, it would be to your peril. You may have a good argument, a bad argument, or a great argument. But that's what you think. A great argument is different from an effective argument. If it's not working with the arbitrator, see it, sense it, try it, push it for a bit, but then learn to give it up. A lot of people lose a lot of cases by hanging on to bad arguments. And it's fine. We spend weeks and months crafting a beautiful argument. You expect the arbitrator to be floored. But it's not working. And in our passion, very often counsels forget to see what is the obvious flaws in their case. And that is why whenever you get a case, I always suggest to put your first impression down on paper. You read the case the first time, you put down your thoughts on paper, because that is exactly the reaction of the arbitrator when they first read the case. And then when you are about to submit your pleadings, I suggest that you read it again. Even to the moot teams I coach, I always tell them, you read the problem once and then put down your arguments from both sides on paper and then forget about it. Email it to me and forget about it. I will show this to you 2 days before your written submissions and 1 night before your oral arguments. Because at the time the arbitrators are reading it, they will have a similar impression. Even in the most complex international arbitrations with most brilliant arbitrators, none of the arbitrators are going to be as thorough with the case as you are. You are the counsel, you're expected to know it just much better. So keep that in mind. Also, in international arbitrations, again, coming back to my point of different cultures, a lot of words have different meanings. And so the way we speak English is very different from how the world, especially non-native English speakers, speak English. A French or a Spanish, for example, speaks English in a much more different and a simpler manner than we do. It's not wrong, it's not grammatically incorrect often, but it's much more simpler. We, on the other hand, have the habit of using things like triple negatives. This action is not unambiguously illegal. And you see the French person, not unambiguously illegal. So what is it exactly? These are things that you should totally avoid. Double and triple negatives is something which is only seen in the native English speakers and countries like India, the States, UK, but a French arbitrator or a Swiss arbitrator will never understand it. Similarly, if you say this act must be sanctioned to a common lawyer, you'll understand that to be okay, this act must be authorized. But to an American, sanction means to penalize. They would say, okay, this act must be penalized. So these are differences in cultures that you should really understand before you are arguing in front of an international tribunal. And how you do that, I will come to this soon. Post-lunch session. Post-lunch sessions you'll have almost every day because arbitration goes from morning to night. But right after lunch, you'll see the arbitrators dozing off. Understand their age and their physical limitations. It is human for them to feel a little sleepy, drowsy after class. We all feel that. After lunch, time in courtroom, it's hard for everybody. So, the advantage in arbitration is you could have quicker breaks. You can choose your own breaks. It's not the 1 to 2 courtroom lunchtime. So you agree with the other side that you'll have a break 45 minutes into the post-lunch session. I generally have a break 45 minutes into the post-lunch session. Now, people think that is way too early. We just had 45 minutes. But that's the time the arbitrators are giving up on trying to snooze their sleep. And that's the time they're really falling asleep. So, before you guys fall asleep, we can take a quick break for about 5-7 minutes. Is that fine? Let's take a 5-minute break. Unless you guys have any questions to ask me before the break. Alright. A judge really do this in courtroom. You've seen? Banging the gavel on... Alright. Okay. Again, that's a first. I've never seen an arbitrator or a judge really do this in real life. Wonderful. That's something new. I didn't really know about that. But that is something you very often just see in movies, but not in an actual courtroom. Personally, in so many years, I have never seen, I've really wanted to see once a judge go like order, order, order. In the House of Law. I'm talking about Indian courts right now. So, this is something very rare. Again, we have one person here who's seen it. I personally have never seen it. I don't know if anybody else has seen it. But that's the point. What you learn from the movies is hazardous advocacy. You really think people who learn their advocacy from movies think that, okay, it's that 10 minutes in the courtroom that is a lawyer's job. But 95% of what your work is not inside an arbitration hearing room or a courtroom. It is behind the scenes. on your brief. So your first job as a counsel is to become an expert on the facts and the law of your case. Okay. Lawyers are selling cases. Have you ever tried buying an equipment from somebody who doesn't know anything about it? It's very common that you just think, okay, maybe I'll buy it from the next one. Somebody who at least knows what they're selling. That's exactly how it is before an arbitrator. You're not selling a product, but you're selling your client's cases. So you're expected to know their briefs better than anybody else in the room. Okay. If you don't know your brief very well, you've lost the confidence of the tribunal very early on. Because arbitration, and I keep repeating this over and over again, is fact-centric advocacy more than legal-centered advocacy. There is nothing that will earn you as many brownie points before an arbitrator as knowing your brief inside out. But once you've prepared your own case, you're just half prepared. Because then you have to also prepare your adversary's case. You can't replace the idea of your adversary with a stick figure, which is very easy to dispatch. Imagine a highly intelligent adversary and then think what are the arguments that he or she will make. And then accordingly draft your own arguments. If you proactively and preemptively think about their argument and raise it, you take the punch out of their own argument. You say it preemptively and you neutrally phrase it in such a manner that when it comes to your opponent saying that same point, it just has much less force on the arbitrator. Every time you have to think, what would the arbitrator be thinking in such a situation? Which brings me to the point that make a detailed character note of the arbitrator from the very start. Yeah.
Sorry, just to take you back to the previous point that you made.
Yeah.
Is it therefore important to present a case from the perspective of both parties in order to make like an effective representation of your argument?
You argue your case from your side, but you should always know what the other side would say. Because otherwise you'll be caught by surprise if you just thought on a single track of your own argument. So you need to constantly think, what would be the counter to my argument? Also, if you've not thought of the other side, there will be obvious flaws in your argument. So you should think about their side, but I'm not saying go argue their side. Think about their side. If they have a key point and you think it can be neutrally put across and addressed in your own presentation, I strongly suggest you do. Because there's a point against you. The arbitrator knows it, you know it. At that moment, the arbitrator knows that you know it and that you're dealing with it. You're not escaping that point and you're dealing with this. You're either conceding or you're opposing that point. Even if you're conceding, you don't come across as ignorant. Because if you concede a point that has to be conceded, you come across as a reasonable counsel. Where an exceptional counsel lies is after conceding, demonstrating how that concession does not hurt my prayer. So concede some points, it is reasonable to do so. Otherwise, if you don't choose your fights wisely and you start sticking on every small issue, you'll just come across as an unreasonable counsel. The arbitrators aren't really going to put weight on the arguments that you really insist on. Does that answer your question? Right. Yeah, Garv. Go ahead. Your name first. Ashwin. Third year. Go ahead.
So one of the issues that I've actually had come up, and this is like on a very personal level, is that when I'm looking into the arguments of the other side, sometimes I start to get convinced by their part, especially if my client or whoever I'm representing has done something shady. So how do you stop yourself from going too far there?
Firstly, that just makes you human. It happens to everybody. It happens to all of us. Second thing, your client never does something shady. But as you go on in practice, you learn to make your peace with a lot of things. I will come back to this point again, but my short answer is that you learn how to deal with it. This is not going to go away, and in fact, it's a good thing that you can see the other side's argument. Just eventually you stop getting convinced by their argument. Also, there will be cases which are flatly against you because you can't change the facts of the case, and they would probably have stronger facts. So in those cases, mitigation would be the best advocacy you have. We had a dispute recently in which our client, for breaking a contract, got sued for upwards of 200 million. Our client had broken the contract. He was going to pay, but not 200 million. Our job was to bring it down to 5, 10, not let it stay at 200. If you read the other side's argument, you'd realize, yes, they're right. But this may or may not be true in every case. It would depend. But as you go on, you'll start making your peace with these things. Okay. So, yes, I forgot your name. Nishant, yes.
So just whenever this fits into your narrative, can you also tell us maybe like some life-changing moments that you've seen or heard in court, like why 95% of work happens outside? Because everyone loves a courtroom drama.
Yeah.
Or even in
In an
Arbitration. Yeah. Again, I get it. Sure, when we reach there, I will certainly bring that point up. But one of the things, life-changing things would probably be too generous to call it, but when I saw advocacy of a lot of international councils, and during law school, I spent a lot of time interning with some of the finest councils in India, criminal and civil, Mr. Soli Sorabji and Mr. Ram Jethmalani and a lot of those people, exceptional and gifted counsels. But when you go outside and you see in international arbitrations, international style of advocacy, you realize that their approach is completely different. You are less overwhelmed, but more easily convinced. A lot of international councils and law firms have the habit of making a character note of the arbitrator, understanding his or her idiosyncrasies from the very start. Now, this might not be absolutely true in mooting. You don't know who your judge is right before your round. During the rounds, you have very little time to understand and observe their idiosyncrasies. But in real life practice, when you're selecting your arbitrator and you're going to be arguing before that person for the next 7 days, 10 days, and multiple times in the span of 2 years, you start making a character note. Read their background. Where did they study? Where did they work? Who was their mentor? Talk to people about them. Find out their hobbies. What motivates them to make decisions to work. Are they theoretically inclined? Are they more practical? Do they prefer flamboyant arguments or do they like swift precision? Were they a trial lawyer or a judge? Were they an appellate lawyer or a judge? Are they really passionate about a particular field like the environment? All of these, if you read in detail and understand about a person, it'll help you humanize the judge or humanize the arbitrator. So that when you're arguing, you're not arguing to chairs, but to persons. A golf analogy would work perfectly in front of a person who's an avid golfer. Again, it'll help you find common ground and make you more likable to the arbitrators, be it on lunchtime conversations or general pleasantries exchanged right outside your arbitration hearing room. Although when you're reading these things about the arbitrator, at that moment you won't really realize how is this relevant or useful. But in the span of the next 2 years that you spend arguing that case, so many times you'll find use of a lot of this ancillary information about the person that you read up for your case. So spend your time understanding the person. My previous boss used to tell me that it's a human profession. Everybody is a human. Understand that they do not logic like computers. So understand the idiosyncrasies of people. Also, during the time that you're arguing in front of arbitrators, start noting down things. When are they vigorously shaking their foot? When is the arbitrator opening her hair and tying it again? And things like these, you'll start noticing them. At first, you won't notice much, but over a span of a week or so, you'll start observing a pattern. And that will help you shape your arguments so much better. You realize that the arbitrator is now getting irritated. You move on to your next point. You realize that the arbitrator is not buying this argument. You try to rephrase it in a different manner. Objective of your advocacy is to make your argument as palatable as possible for the arbitrator. Again, don't think of your arguments from your own perspective. See how it will look to a third party, to an arbitrator. And this is the mistake a lot of people make. They don't make their arguments palatable to the arbitrator, which is my segue to our written advocacy section. Yeah.
For that, could you just as easily translate this same logic to courtroom argument?
Yes, but there are a lot of difficulties with this. Firstly, okay, it's easy as well as difficult, I must say. It's easier in one aspect because it's easier to read about the judge. You can see his or her previous judgments, read them up, and understand what motivates this person to come to conclusions. Is it theory? Is it practice? Is it logic? Is it policy? What motivates the persons to draw conclusions, logical deductions, and inferences from facts? In arbitration, as the awards aren't published, this is harder to do. But in practice, your judge is probably not going to remain the same throughout the course of your hearing. In 10 years or 20 years, you will probably have 4 times the number of judges. Every 6 months, it's very often for rosters to be changed. You'll have so many times, the clock will be set back to 0 again. So many times you'll have to start from square one because you have a new judge who doesn't know anything about your case, even if he or she may have read the synopsis and list of dates and things like that, but the understanding that you had conveyed to the previous judge has been lost. So in courtroom advocacy, you'd either have to do it over and over again, or you just have to have a battery of associates doing it for you. Okay, so this is much more applicable to arbitration. But as I said, almost everything I say here can be adapted to courtroom arbitration. Just don't cut, copy, paste like a project. Do it, like adapt it to the situation. And that is what most counsels lack doing. They have fantastic experience in arbitration, even some renowned senior counsels, exceptional in courtroom. But then if you take that same advocacy style to an arbitration, it may not be effective. Yes.
Before we move into the written arguments,
Yeah.
questions.
Go ahead.
Firstly, with respect to technical aspects, say for instance the quantification of damages, how should those be approached orally? They could get extremely abstruse for perhaps not arbitrators, but for your client or even for yourself. So how would you approach that?
How about you park this question, because I'll start with written, but I will go on to oral advocacy. And this is a relevant question, but we would address it at the right juncture at oral advocacy. Yes, go ahead.
Yeah, so
Louder.
the second question was, what do you think of the idea of splitting counsel in an arbitration and ensuring that each issue is argued by the specialist in that issue? For instance, if there's an English law element involved, you could get a QC down just for that. Do you think that would interfere with continuity? Do you think that would expose you to questioning on
other aspects of the case that you aren't that familiar with? How would you approach something like that?
Again, a question very relevant, but more relevant at the oral advocacy stage. My short answer would be, I have very recently seen good cop, bad cop work brilliantly in an arbitration. But I will come to this point as we go ahead. If I miss this point, just remind me when we are at oral advocacy stage. Because discussing oral advocacy right now is putting the cart before the horse. It takes a lot of time before you reach to the oral advocacy stage. Now, for the first and second years, let me quickly run you through the general lifespan of an arbitration. And this would be different depending on the rules applicable, depending on a lot of factors, agreements of parties, but a general arbitration would look something like this. Claimant sends a request for arbitration. There's a reply to that request. The tribunal is constituted. You file a statement of claim. There's a reply, which is the statement of defense. Then a reply to the statement of defense. Then you come to the stage of hearings, where first you make an opening statement. Then you have the evidence stage, where both the parties bring in their own witnesses. There's examination, cross-examination, re-examination. After that, there is closing statements, and then post-hearing briefs, which are short briefs that you give to the tribunal after the conclusion of your arbitration. After that, the tribunal takes a few months to deliberate and comes up with their decision, which is called an award. Now, your written advocacy starts much prior to even the first time you see your arbitrators. In most cases, especially in international arbitration, it's 6 months into your arbitration that you really see your arbitrator for the first time. Very often. Could happen otherwise, but more often than not, it's your written communication through which the tribunal will make the first impressions of you as a counsel, your client as a party, and the case as a whole. It is also the first real impression for your client. Be sure that your client will read your pleadings cover to cover. They are paying through their noses for it, and they must understand it. If you just put so much legal jargon that they won't understand it, it's not going to be useful to the client, and he or she is not going to be happy with your performance. Okay, so it is going to be something that inspires confidence even in your client. But again, you can't do everything as per your client, right? Your client would expect you to go out there, kill it. But you perhaps would know better. Knowing the arbitrator, understanding his background, you would realize that perhaps it is not best to go with a combative style. It's better to go with a more restrained style. So trust your instincts and trust your judgment on that. Because based on your advocacy, written pleadings, the arbitrators would have already made up 60% of their minds before they enter into an arbitration hearing. So what you need is a compelling case theory. Your case theory is the golden string that runs through your arguments. It's a compelling narrative accounting for all the credible evidence, including the unhelpful evidence, supported by the applicable law. I always suggest people to have a one-page case theory with them at all times, even if you are at advanced stages in your arbitration, because that is your one-page summary of your case. If you had to explain that case to a layman, how would you do it? Keep that in mind and make your case theory. There is probably nothing as important as making your case theory, that single narrative that explains it all. Again, in arbitration, unlike in courtroom, there are no fixed rules. Courts, you have your civil procedure code, which will tell you which documents to be filed at what dates, what time, how much time between documents, what are the objections. Nothing like that exists in arbitration. So there is nothing uniform. It all depends on what institutional rules are applicable. If it's not institutional, what does the law of the seat would say? What are the other rules applicable? If it's an Indian seated arbitration ad hoc, you go look at the Arbitration Conciliation Act and things like that. But there is no standard uniform way of pleadings being structured in international arbitration. For example, UNCITRAL and LCIA rules provide for a statement of case and defense, whereas a statement of claim and defense, whereas ICC rules provide for a request for arbitration and a reply. Now, so what you do, you read your institutional rules and you make your mind accordingly. If you don't have institutional rules, look at the other procedural laws applicable and decide. But the point I'm driving here is that there is no uniformity. Best way, ask the tribunal at an early stage what they want. Understand very early on what the tribunal is looking for. It may be a very diverse tribunal where people come from different cultures. A civil lawyer and a common lawyer have a very different approach towards pleadings. Some want everything in your pleadings, some want just a skeleton. You'll even see this in mooting. Some moots you'll find just require a skeleton memo. Like Frankfurt, I think Frankfurt investment in FDI. FDI at the national round stage requires a skeleton memo and at a later stage requires full memos. But again, depending on the culture that your arbitrators are coming from is what they would be expecting. Realize the fact that it's not even certain that the arbitrators are on the same page regarding that. They may be from 3 different cultures and 3 of them would be expecting 3 different things. The best way is to ask them early on, what are you expecting? What are you looking for in this case and how are you expecting the counsels to present that to you? That is the best possible way. Again, with drafting, the golden rule is KISS, keep it simple and for the stupid. Now, this is not at all to say that even some of the arbitrators are stupid. They are not. They are there for a reason. But your arguments are not always going to be read by the highly intelligent arbitrators cover to cover. A lot of time it will be their assistants, their juniors and associates. So your argument should be formulated in such a simple manner that everybody can understand it. And it doesn't require like 40 years of experience to really make sense of what you are arguing as a counsel. The art of articulation is very undervalued. And it has to be disciplined. Now, there's this quote by Blaise Pascal that says, if I had more time, my letter would be shorter. It takes much more time to make a 1-page document than it takes to make a 5-page document. Because 5-page you have the kitchen sink approach, you throw everything in. 1 page you need to be very incisive. So, art of articulation is highly undervalued. Now, I was asked a while ago what was one of the life-changing moments. Now, I don't know if this was life-changing. It's still too early for me to say. But when I was working with an arbitrator, one time I saw a new case coming to the arbitrator, and like this case had already been initiated. This was the time when the documents were coming in. And although generally it is statement of claim and then 2 months later statement of defense and then counterclaim, often you have parallel exchanges. That is, at the same time you're exchanging your statement of claim and then your replies. So I reached office one morning and saw that my whole corner of the office had been taken up by files. There were 27 volumes of files stacked from bottom to top. The time I was counting the number of volumes that have actually been dumped on our desk is the time when FedEx rang the bell and we realized that now we have the submissions from the other side. That was 32 volumes. Soon thereafter, in a week's time, we had the reply. And then we had the evidence and the documents piled on. By the end of it, we needed an extra room just to keep the files. Now realize the plight of an arbitrator, 60 years, 70 years old. Suddenly you're dumped with a room full of documents and you are expected to read them. The moment I saw that is the moment I realized that we are becoming very inconsiderate about an arbitrator. It takes, when you look at those files, you smell the blood and sweat of a battery of associates who spent a week in a windowless basement far away from their families, not having met their families for a long time. You can feel that. And if you want your arbitrator to read that, it is humanly impossible for one person to read it. They need a team to read it. If you have a team to read it, it's not your arbitrator who's doing the job. So there has to be a balance struck. You have to be much more considerate of your arbitrators because it is humanly impossible for them to read all of that. Now, I attended this session at Toby Landau a few months ago, and he said there are 2 lies that every arbitrator says at the start of a hearing. They're absolutely lies. First, we are very grateful to counsel for all the submissions they have made. And second, we have read your pleadings and don't feel the need to repeat them. This is something which is an absolute lie. But you can't start educating the arbitrator from scratch because they're the arbitrators. They really know, most of the times they know adjudication much better than you know advocacy. They have seen adjudication across the board, advocacy across the board. And therefore, the oversmart tricks won't work on them. But they do realize when a counsel is trying to make their job easier. So do that. Don't switch on autopilot and go textbook ways. At every stage, keep thinking how you make the arbitrator's job easier. If there are a lot of names of entities and persons involved, have a list of dramatis personae that they can keep referring back to because it's human that they will forget who's who. Also, too many companies make corporate structure diagrams. A lot of flexibility that you wouldn't otherwise have in courtroom, you'd have in your written pleadings. Because, for example, when we file a special leave petition before the Supreme Court, it's a form. It's a set pattern with like checklist. It's a checklist that you have to tick. But you don't have chances to do out-of-box things. In arbitration, you do have that chance. Because your objective is just to persuade. And the limits are much less than in courtroom advocacy. Yes?
This is more of a general question of taste with respect to what you adopt. But considering that there are very, very few boundaries in written advocacy and arbitration, you often could see counsel adopt extremely radical approaches. For instance, I've seen pleadings where both parties were narrating stories, and I was so sold by the end of each rhetorical pleading that I thought I'd give it to them if I were arbitrator, only to sway after reading the other side's pleadings. And some of the techniques they adopted were in order to debunk the various myths that the other party was placing before the tribunal. They listed out red herring number 1, red herring number 2, red herring number 3. So would you adopt that radical approach, that rhetorical approach, or would you play it safe and do it in a slightly more court-like manner?
Again, my answer will always be depends. It depends very much on the facts of the case. Depends on who the tribunal is and who the opposite counsel is. What I want to impress upon all of you is that never switch on autopilot. In a particular case, probably that would have been excellent strategy because, as you say, you were convinced by both. So that was good strategy. But in some cases, it will end up really annoying your arbitrator or the opposite counsel. And you have to realize there is value for hierarchy at the bar. So if you do have a senior counsel against you and you do irritate or say something which is very caustic to him, debunking his theory in a very disrespectful manner, it's not going to be appreciated even by the arbitrators. Because at the end of the day, you may be arguing your case, but you do have to do it with a certain degree of respect. Again, you do it respectfully, but you do your job well. So every time take a judgment call that in the given set of factors involved in my case, would this be a good strategy? Understand people. A lot of arbitration advocacy and advocacy in general is understanding people, understanding what motivates them to come to conclusions. Also, you never assume ceteris paribus. You don't assume all other factors remaining constant because they never are. See what are the other factors that would influence the arbitrator's decision making or even any person's decision making at times. Personally, I love to run my argument by my cousins who are still in primary school. Because at that time, I have to break down my argument as if I'm explaining it to a 12-year-old. You break your argument down to basics and you see it for yourself. Okay, logically, this does not make so much sense. Legally making sense and logically making sense are two different things. And in arbitration, and here some people would differ, I always say that the backbone of your arguments should always be logic rather than law. Also, when I say understand the other person, realize that the arbitrators have much shorter attention spans than you do. If you expect them to read all of that, they will get bored. So it's your job to tell a compelling and interesting story. Because much of advocacy is about storytelling. And telling the story in a manner so as to capture and retain the attention of the tribunal throughout your arguments. Indians are very infamous outside for circumlocution. We have a habit of using a lot of flowery words to make very little sense. And this has been pointed out to me over and over again. In fact, I'd written my thesis under Gabrielle Kaufman-Kohler, and when I got my comments back from her, so many places she had just rephrased what I had said in a paragraph in 7 words. And I realized, that's exactly what I'm seeing. So it's something that we all do. When you explain your arguments to kids, you don't use those flowery words. You say it as it is. That really is the time you realize that the same thing can be said in a much simpler manner. If you start doing this, the size of your pleadings will automatically shrink because you don't need 40 words to say and 4 lines to say what you can say in 1 line. So avoid circumlocution and always keep logic as the backbone of your arguments. Now, when you begin drafting, how do you go about it? A lot of advocacy, as I said, is about storytelling. Set out the full story from the start. Don't save your punches for the end or for the hearing. If you save your punches for the end, in all probability, nobody is going to read it till the end. If you save your punches for the hearing, the tribunal and the other side will note it and it won't go down well. So, don't save your punches. Start off with them. Again, when you start drafting, make a roadmap of the things that you plan to do. And then add your own timeline. Within these days, I want to finish this. Next milestone for myself is this. So make your own milestone roadmap and set your own time frames for it. Now, another thing I learned after I started practice was that you don't take a point of law, look up a commentary, read from both sides. That's the wrong start. You take the prayer and then you back calculate. What do you want to achieve your prayer? In real advocacy, outside law schools, your prayer is the most important part. So you back calculate from your prayer and then find out ways to get to that prayer. When you do that, I suggest translate the flow of your arguments into a flow chart. This is, have your prayer at the end and then find a way to get to your prayer through a flow chart. It will organize and structure your thoughts and arguments much better than any other thing could. And this is just my experience. Probably you can come up with something very different and which could work much better for you. Somebody does it differently. But in my experience, this really helps and it helps you stay on track. Shape your pleadings not for your own convenience, but for the convenience of the arbitrators. Again, every time I say this, try to look at it from the other side. How would the arbitrator digest this? Keep thinking about the arbitrator and how useful they would find it. At that time, right before you're going and submitting your pleadings, is when I suggest you read that first impression 1 page that you made at the start when you got the case. Because at that time, you will get so many ideas at the last moment from your first impression. Right now, this may not really, this is not something you will understand perfectly right now. But if you really do this, again I repeat, the time you get the case, read it once, put your first impression down on paper, fold it, forget it. Right before you're submitting your pleadings, open that again, read it. You'll get so many more ideas. Because this is how the arbitrator will think about it. Because from the time you got the case to the time you're submitting your pleadings, a long period would have elapsed where you would have delved so deep into every argument that now you are internalizing your arguments. You are just thinking in one direction. But you're not thinking about what is the first impression of the case. So, I suggest at this stage, read that. A lot of studies have shown that nobody or people just don't have a tendency to start what they cannot finish. If for this class I had prescribed a reading material of 400 pages, most of you wouldn't have even started. A lot of you wouldn't have even just turned up thinking that we had to read so much. I didn't read, I'm not going. So people don't have a tendency to start what they cannot finish. Same goes for arbitrators. You put so many files on their desk, it's most likely that they won't read it. What you can do to avoid this is get into a habit of giving executive summaries. Before you start your pleadings, give an executive summary. Before you start a specific argument, give a 1-paragraph executive summary. So even though they may not have the time to read the whole thing, they read your executive summary and they get an idea of what is the tangent on which you're arguing. Yeah, Garv.
I'm Shweta from the third year. So we mentioned this earlier as well, how you have to be succinct and precise when giving your arguments. My question here being that often when we do go on long tangents, because we want to provide context and like elaborate on this point which we feel is important. How do you draw the balance between giving the proper amount of context and also being succinct and precise?
Again, see, a lot of these questions are very general and cannot be answered without the real context to such a question. Which makes your point perfectly that some things require a context. The art lies in where to draw the line. There is no straitjacket way, I can tell you, that 20% for the point and 40% for the context and rest for the other ancillary things. It doesn't work that way. Because this is not mathematical. It's much more a social science. So what you can really do is have executive summaries without the context, which give a bird's eye view of your point. But then when you go on further in your pleadings, you give the context as well, as much as you need. But your executive summary, I suggest do not have context. Just have the point you're driving home from your whole next few paragraphs or pages, which the arbitrator may or may not have the time to read. Also, at the start of your pleadings, have an executive summary of all the sub-point executive summaries that you have in your pleadings. If I wasn't very clear here, every sub-point should have a short executive summary, and the whole document should have a slightly longer executive summary, which is again a summary of all the points you've made in your sub-points. And that executive summary should look very similar to your case theory. The compelling narrative, which is that golden string that runs through your complete arguments. Again, time and again I'm telling you, think like arbitrators. Build in, zoom out mechanisms in your pleadings for the convenience of the arbitrators. Which means decimalize. Although it may look weird, 1 point, 2 point, 7 point, whatever. But in reality, it's just way more practical. A lot of us have the habit of A, B, C, D, Roman 1, 2, 3, 4, then small 1, 2, 3, 4, then small A, B. It is so confusing. 1.1.2, 1.1.3, 1.1.3.4. It's easier for the arbitrator to zoom in and zoom out of your pleadings. Because at the end of the day, they know all of this is a sub-point of 1. So, I always suggest people to decimalize in their pleadings. Again, in international arbitration, it could be useful to add a case law on the point from the jurisdiction of the arbitrators. Now, this is a tricky thing. Firstly, it's not the law applicable often, but it could be something that the arbitrator relates to much more than a third law. The problem here is, if it's on a grey area, don't do it, because you don't want to go down that rabbit hole of arguing with the arbitrator on his law when this is not even applicable law. It's just a persuasive authority which you think will click with the arbitrator much more than other cases. In your pleadings, yeah.
How would you approach a particular legal concept that is understood very, very differently in the common law and civil law world? If you have arbitrators from the common law and civil law, or even within the common law world. For instance, voidable distinctions, good faith duties. Would you try to go for the lowest common denominator? Would you sell hard to perhaps the presiding arbitrator? How would you go about something?
Okay. Selling hard to the presiding arbitrator is a strategy I am generally never too supportive of, because at the end of the day, it's not that the arbitrator's appointing authority is who he or she owes their loyalty to. Its dissents are not that common in international arbitration. They are there, but not as common. So more often than not, it's a unanimous tribunal. Now, this happens very often in international arbitrations. If you have on the bench, on the tribunal, you have a QC, a very senior, let's say, Swiss lawyer, and an American lawyer. All of them would have different understandings of concepts like good faith. Here, one strategy could be finding the lowest common denominator. I would suggest that always fall back upon what is the applicable law. Because at the end of the day, their obligation is to define that term and determine the dispute according to the applicable law. But it's not as mathematical. So you have to address how that term is interpreted in their jurisdictions. But distinguish it from the facts of this case, because the applicable law here has a different interpretation of that. So my suggestion, and this is the way to go about it, always fall back upon the applicable law. But just don't jump onto the applicable law. Tell them that this is understood in different jurisdictions separately. But here, this being the applicable law, this is the interpretation that should be applied in our particular case. Alright. Now we're still at our pleadings. We're quickly closing our pleadings written submissions. So I will speed up a bit. Cite those paragraphs in your pleadings that you want to be seen in your award. Just don't keep on citing from different cases just to show that, okay, you've read a lot. That doesn't really make a difference. Practically, in international arbitrations, very little use of case law is done. It's 80% revolves around facts. Because again, when so many different arbitrators from different jurisdictions, they are not expected to really deal with facts like the Supreme Court or Cour de Cassation of a country really deals with a pure question of law. Again, here a lot of people differ with me, but I think as we go further into commercial dispute resolution and ideals of justice do not necessarily overlap. So again, cite those points which you want to see in your award. Bold, italics, underline. Please use them very sparingly. They're not much appreciated and you lose the punch if you use it too often. Consistency. It's very often seen that there's no consistency in pleadings. One side it's written 05.03.2017. One side it's written 5th of March. One side it's written the other way. Don't do that. Because arbitrators, if they are from 3 different cultures, they'll first get used to the understanding, okay, throughout the brief, this is how it's going to be. And then they see, okay, now he's done it differently. So, uniformity. Also in currencies. Now, when you do international arbitrations, especially on international transactions, there are so many currencies involved and often the arbitrators understand a different currency. So, learn to put everything in a common currency and then go ahead. While drafting, it's very important to pause effectively. Take a break and step back from your work. Pausing and taking breaks is very important because that will help you edit better. It is fine to draft garbage so long as you edit brilliantly. So you start drafting early. You research and add parallelly. Now, this is something a lot of us don't do. I've started now forcing myself to do it. Earlier, my idea was, okay, I will research and then on this date, I will start drafting. This is not the best way to go about it. Start drafting from an early stage. Again, I said, it's fine to draft garbage so long as you edit brilliantly. So, start drafting at a very early stage. As in when you research, make copyable notes and keep adding to your drafts. And leave at least 20% time for your editing. That's the time when you really edit it. As you start doing this process over and over again in various different cases, start making a personalized checklist on the common mistakes you make. The index of the favorite citations you have. For example, Redfern Hunter. Everybody refers to Redfern Hunter, Gary Bond all the time. Make your own list of index of citations so that next time you're not typing that whole thing again. You're just taking and copying it. One more thing. In India, we have a habit of para by para denials. This para is denied. Para 42 is denied. Para 47 is denied for want of being unfounded or for lack of evidence. This is not a practice in international arbitration. If you deny, you can deny it wholly. You want to deny it specifically, then don't start off with that. Denials are generally supposed to be done in the middle. Refuting your case, the opposite side's case, should always be done in the middle. Park this thought. I will come back to this. Because now is the time we move to oral advocacy. Yes.
Respect to that point, how do you approach different forms of argument in an arbitration where you have different stages of solutions? For instance, in an ICC arbitration where you have your request for arbitration and your answer to request for arbitration and then your memorials possibly, would you just go with fact initially in your request for arbitration? Would you possibly conceal certain trump cards at that stage? When you're answering to the request, would you take I deny this paragraph, because I have seen that from an English form? Would you then bring out everything in your memorial?
Again, it would very much depend on who my tribunal is. Now, generally in international arbitrations, it is very much frowned upon if you don't disclose things that could have previously been disclosed. The meaning of trump cards has changed recently in the last few years, but some secret weapons, if you may want to call it, or some facts that would have the possibility of changing the fate of your case. If you could have put it during your pleading stage and you don't, you conceal them and disclose them at a later stage, in all probability it will lose its punch because the arbitrators are not going to look upon it favorably. Obviously, your opposite counsel is going to object to this, that you could have raised this point earlier, you deliberately chose to conceal it, and the arbitrators are going to notice this. So, I personally do not suggest this, but then again, it depends on who your arbitrators are. If your research about the person shows that the arbitrator is himself or herself in a habit of doing that, then it's not a practice that he or she will frown upon. So, everything has to pass through that test of who my tribunal is. Alright, so with this we can segue into oral advocacy. This should take about 15 minutes, I'm guessing. And then we'll have some time for questions. Again, please interrupt me whenever you want. We are getting a lot of questions from this side. I'm hearing less from this side. So any queries you have, you can interrupt me or save them for once I'm done with the oral advocacy. Oral advocacy is your first real chance to engage with the tribunal. It's the time you meet the tribunal, often for the first time. Don't use it to rehash the things you've already said in your written statements. Lay your case theory. Tell them that this is my case. Just don't overdo it. Just don't have extremely long opening statements because they won't really have much of impact. I recently saw an arbitration in which the claimant's opening statement was about 4 hours long and the respondent's opening statement was 17 minutes. Trust me, the respondent was much more effective.
Who won?
It's still going on. We haven't had the award yet. But personally, I thought the respondent was much more effective, and it was evident. Because with that, you show that they are unnecessarily trying to complicate the case. This case is as simple as this. So, again, just don't try to fill up pages. In India also, there is a habit just to show my client that I've done a lot of work. I've produced so much pages after pages after pages. But the reality is, it may look good to your client, but he's not going to be happy if it's not effective. At a later stage, when you suddenly realize that nobody's reading that, that's the time you'd realize that you should have taken a stand and been much more articulate. So always keep this in mind, that opening statements is the first chance to be engaging with the concerns of the tribunal. They've already made up 60% of their mind. Understand at this stage what are their concerns. Use logic and fit law in it. Start your storytelling, but don't make a speech. In arbitration, eye contact is much more important than it is in a courtroom. So, please don't read a speech. Nothing will justify you reading your speech. It's fine to have a speech in front of you. It's fine to keep reading this. Again, when I started off as a mooter, I used to make a proper speech word by word. Good morning to the last word, thank you for your patience, and I rest my case, or things like that. Eventually, I moved on to a line of arguments. This is going to be a process. By the time a lot of people become senior counsels, they just have 5 points in front of them, and they can argue the whole day just from those 5 points. So it takes time, but don't read a speech. If you read a speech, it's not going to be effective at all. You may have seen in court people reading a speech. Realize that in arbitration, the same thing would be even half as effective, because eye contact is much more important in arbitration. Again, give a roadmap. When you're starting off arguing, give the arbitrators a roadmap so that they know where they're going. How much time would it take tentatively? Where will you move to the next point? If they have an idea, then it's just going to be way more comfortable. So tell them what you're going to tell them. Then tell them that, and tell them what you've just told them. Open, give your point, and summarize your point. That is the way you will have finally properly impressed your point upon the arbitrators. Now, probably in oral advocacy, there is nothing I will say which is as important as the point I'm going to make now. It's okay to be scared. It's very often that we are faced with, maybe we are mooting, we are arguing before a court or a tribunal. You think, okay, I'm fretting, I'm nervous, I don't know what I'll say, I'm daunted by the chance, the opportunity. The thing is, it's okay to be scared. When I was invited by Nyaya initiative to talk to you about arbitration advocacy, what do you think? Obviously, I was scared. I saw the people who've spoken to you before. I realized, okay, these are the people I'd apply for internship I'd apply for internships under. I studied at GNLU, so I know all of you are probably smarter than I am. So again, it's okay to be scared. As you go further in your profession, you will learn to make peace with this. I'd asked a similar question to Mr. Jethmalani in my final year. And he told me that even when you've progressed further in your profession, 20, 30 years down the line, you'll be arguing a national importance matter in front of 7 judges. You'll still be scared. It's human, it's natural to be scared. Just don't let fears overcome you. But realize that it's okay to be scared. There'll be so many times when you are challenging an arbitrator in the arbitration proceedings. You would be scared. And in a mood that might not seem like a very big thing, the arbitrator is expecting that. But in reality, the arbitrators do get offended. It's a risk, it's a judgment call you're taking of offending the arbitrator. And if he dismisses the challenge, you're still going to be arguing for the next 1 year in front of that same person that you challenged. So you will be scared. Even 10 years, 20 years later, when you're arguing, there will be times that your legs will tremble. So that feeling isn't going away anywhere. Learn to make your peace with it. So long as it doesn't show. It shouldn't show on your face. You shouldn't stutter. You shouldn't really lose your whereabouts and of what you're arguing, what you're submitting. Because appearances are gold. It makes a huge difference, and it reinforces the arbitrator's perception of you. If you don't have a single binder and you have like loose sheets falling all over, you're so flustered, you lose a lot of attention of the arbitrator. So appearances are gold. That's okay. It's been a long time he's been avoiding that call. I started with this point and I kept repeating this point. Adaptability, malleability is the biggest thing you can do as a counsel. Being a rebel, however big your stature is never going to help in an arbitration. You have to persuade your arbitrator in a manner most palatable. I saw an arbitration in which we had a towering senior counsel, very renowned internationally, arguing before a tribunal of renowned arbitrators, but again not as distinguished as the senior counsel who was arguing. But then, big people have big egos. That happens, and at the end of the day, just because he's a big man, the arbitrator is not going to make up his mind. And if egos clash, the arbitrator will have the last word. So understand that being a rebel will never work. Make your argument in the manner most palatable. Modulate your voice. Realize when the arbitrators are losing attention. Tell them when you're coming to a key point. Signposting is very important. There'll be very often when you see your arbitrator is looking into his phone, he's thinking about something and you realize it. At that time, tell them, Mr. Arbitrator, the next point I'm about to make, my case turns on it. It's a key point. At that moment, you have their attention back. Things like this. Pausing effectively also makes a difference. The arbitrator will realize when he's used to, radio playing in the background, suddenly it stopped. You've made an effective pause, but you've got the attention back. A few things that you should absolutely do during oral arguments, and this is a checklist I'm going to quickly run through. Lay the standard of proof. You don't have to go further than you're supposed to. If you have to prove only till a particular point, don't pitch your case higher. It's just going to make your own job more difficult. Make eye contact with everybody and not just the president. Even the arbitrators who don't seem interested, make eye contact with them. If the arbitrator wants to engage in irrelevant banter, don't stop him or her. Let them do that. Okay? Because if you do stop them, it will irritate them. Be likable, but do not flatter. They see flattery. Most of them, especially in India, are very used to sitting on the bench or the tribunal. So they've seen flattery of all sorts. They smell it from a distance. So do not flatter, but be respectful. Be courteous. And your wit and humor are some of the most undervalued tools. In a lot of cases, which could go either way. For example, there is a case, let's say on construction arbitration, delay. At the end of the day, you know there's a delay. Every time it will revolve around who is the delay attributable to. You'll have arguments from both sides, you'll read both their case theories, and it will be so convincing that you buy both sides. So will the arbitrator. At that time, it will make a huge difference on how much the arbitrator likes the counsel, the party, the case. That's why appearances, courtesies, which are very undervalued, are very important, especially in those grey cases. Because, as I said earlier, we trust those people that we like much more readily than we trust anybody else. So if the arbitrator has a good impression on you, if you have a good rapport developed over the case with the arbitrator, and it is very hard to pinpoint the blame, but a decision has to be made, this would be a very major motivating factor. Other factors would be your body language. It would make a difference how fidgety you are, how much eye contact you make with the arbitrators. All of this is going to make a major difference in those gray area cases. Now, one of the very stupid things we counsels do is criminal law style objections in arbitration. Objection, my lord. I have heard this way too many times recently, and every time it irritates the arbitrator so much, because arbitration advocacy, you don't really have so much objections on every small point. So choose your fights wisely. Don't fight unnecessarily. If you show your aggression on petty issues, the issues where you actually need to show aggression and push, the arbitrator is not going to take you seriously. And again, as I said, when you concede, you come across as reasonable. Your advocacy lies in turning around and saying that although I have conceded, this does not hurt my prayer. Now, I was telling you, refute the case of your adversary in the middle. A lot of times, people arguing second start with the case of their opponent. You hear your claimant saying, and you realize, oh, he's arguing utter bullshit. I will demolish his case and show to the arbitrators how wrong he is. So you will start off saying, okay, point 1, this is wrong. Point 2, this is wrong. Point 3, this is wrong. But what you've done is you've started with a defensive note. Don't do that. Start with your own case. Make your own case theory. You are so convinced with your case that you will first make your own case theory. But even when you're making your case theory, the arbitrator is still slightly convinced by the other side. So at that time, start refuting that their argument has no legs to stand on. Red herring 1, 2, 3, 4. But don't stop there. Come back to your own case, because otherwise that's the lasting impression you leave on the tribunal. You don't start off with their case, you don't end with their case. If you end with their case, the tribunal is going to go home thinking about their case and not your case. So always refute at the end. Aggression, even in refuting, is never going to be appreciated. I attended this session by Sir Christopher Greenwood, who was at that time a judge of the ICJ, and he's telling us about his experiences arbitrating disputes, especially investment arbitrations. He said, many counsels consider arbitration to be an extension of Game of Thrones, just with more bloodshed. So please don't do that. It's a much more civil, peaceful way of dispute settlement. It's much more business-like. It's not grabbing throat advocacy. Cross-examination does not have to be cross. In fact, it should never be cross. In arbitration, it is never appreciated. In most cases, by a rule of thumb, it's not appreciated to question the character of a witness, unless that itself is a material issue in the arbitration. So don't go after the witness personally. That is not appreciated. Even in criminal law, you could still get away with this. In arbitration, in all probability, nobody's going to really appreciate it. Regarding the point you raised of multiple counsels. Now, I personally always thought that doesn't work. Until recently, I saw it work brilliantly. So I have changed my mind about that. But there is a way to do this. So the arbitration I recently saw, there was a senior counsel and there was a junior partner of a law firm, and both pulled off a good cop, bad cop beautifully. The senior counsel took all the factual witnesses and the junior counsel took the expert witnesses. Now, there was only one expert witness, but a lot of factual witnesses were also raising some points So related to the expert witness, because it was a technical project, it was an energy project, so they'd gone about it. Now, in that situation, there was a clear demarcation and there was permission of the tribunal sought in advance. But not all tribunals will be receptive to this. Understand how the tribunal reacts to your request before pressing it. But be prepared that it may not be answered. You should always prepare that one counsel is going to do the whole thing. But if you think that somebody else can do it better, some sections, especially in large technical cases, ask the permission of the tribunal. And depending on the tribunal, they will accept or reject your request. But again, everything I say here comes back to the same thing. The tribunal. Your job is just to convince the tribunal and not to make a brilliant argument. You think that if 5 associates dealt with a particular issue, they would know the issue best, they all should argue. But that doesn't work. The tribunal gets used to a particular style of being addressed, and that's what they prefer. So, more than 2, I would never suggest. But in some cases, 2 works. And I've just recently seen that, that's why I say this.
To bring up the topic of witnesses and expert witnesses, I have 2 related questions.
Yeah.
Firstly, in a situation where your expert witness is making observations that are completely at odds with the other expert witness and the case could turn on that, would you resort to witness conferencing? If you did, how would you treat your expert witness? Would you leave it in his hands? Would you prep him at advocacy? How would you go about that? And that ties into my second question, which is, do you generally prefer to prep your witnesses or take a hands-off approach and let them do things the way they do?
The same caveats apply that there's no straitjacket way. But generally, starting from your first question, if there's a very clear divergence in both my experts, I'd first want to realize if witness conferencing, hot tubbing, all of these things are in my favor or not. Accordingly, I will make the strategy that whether I want that or not. Secondly,
That on the point of hot tubbing, what role does the counsel have to play when 2 expert witnesses are going?
And could you just explain that concept further?
okay, hot tubbing is just a slang for when you have multiple expert witnesses together, discussing the point together in front of the tribunal, examining, cross-examining each other. The fact is, when it's a highly technical thing like an oil and gas project, something like an offshore rig, there's only so much that lawyers and arbitrators understand. But technical issues are only understood by the experts. So I as claimant will bring my own experts, the respondent will bring his or her own experts. Generally how it goes is that my expert will give a witness statement, which is his examination in chief, and then will be cross-examined by the other counsel, and the same would be done for their witness, expert witness. But the thing is, when this gets too complicated, very often you resort to witness conferencing and hot tubbing, whereby you bring all the experts together and ask them to discuss and try to first find common ground. If they can agree on 2 out of 5 issues, you have 2 less issues to debate. Then on those 3 issues, very often you have the witnesses question each other in the presence of the tribunal, picking holes in each other's theories. Now, it's just easier because first lawyers would have to understand that highly technical concept, then examine an expert in that area, and then explain it to an arbitrator who himself doesn't really know that subject. So it's just for efficiency purposes that these things have been evolved. Now, personally, prepping witnesses differs from country to country. That's dependent on legal cultures. I don't have an answer on one end of the spectrum. There's always a balance. You do not tell your witness what to say because it's not an argument. It's a witness saying what he or she is saying. But then you read their witness statements. In arbitration, there is no chief examination. Mostly there is no chief examination like there is in civil trials. So you generally have the witness giving his own testimony in the form of an affidavit. That affidavit should be in the words of the witness himself. Otherwise, the tribunal is not going to buy it. If the affidavit sounds like it's been drafted by a lawyer, nobody's going to put any weight on it. So it has to be in the own words of the witness. However, it's fine to caution your witness about some areas that the other side may want to drag them down some rabbit holes that they want to avoid. But again, there is a balance that has to be made. The answer cannot lie on either end of the spectrum. So, just to quickly wind up, at the end of your oral arguments, always give a written summary note of what you just argued. I think if you hand the summary note as the last document at the end of the hearing, it's that thing that will give a lasting impression. It's very often that that's the first thing that the arbitrator will read when he goes back home or in the car on the way back home. And whenever they open the file the next time, it's that which is going to be the first document on top. So I suggest giving them a one-page summary of your oral arguments at the end of each day. Now, I'd end with the anecdote of a sleeping arbitrator. And believe it or not, we face this very often. What do you do if your arbitrator is sleeping? We recently had an arbitration in which the sole arbitrator slept off. So there's the claimant counsel, there's the respondent counsel, and what should we do? We should argue to the air. The arbitrator is sleeping. But it's human, it's natural. Judges sleep, arbitrators sleep off. They're human. It's not that they're disinterested, but it's just that they dozed off. They're elderly people. It's very natural for this to happen. Now, what would you do in such a situation? If your arbitrator is sleeping, it's a sole arbitration. The only person who really matters in the room is sleeping. I saw somebody pull off a stunt very beautifully, and that's what I'd share with you. The counsel who was arguing, he realized that the arbitrator is sleeping. He had a pile of books next to him, and he threw them on the floor with full force. So hard that it startled the arbitrator. Arbitrator got up, and the counsel apologized. I'm sorry, Mr. Arbitrator. My hand slipped, the books fell down. I think I'm losing my orientation. Perhaps I could really use a coffee break right now. And that is what really worked. Anyway, that brings me to the end of my session. I thank you all for your patience. You've really given me a lot of it. And before I close, if there are any questions, please feel free to ask them if you didn't ask any on the way. Or if you're too shy to ask those questions, you can ask me them outside. Again, thank you, Nyaya, for inviting me. And thank you, Nalsar, for hosting me.
Right, I'll pass the mic around to anyone who has any questions. So, raise your hands. Or we can take it outside.
I think.
There are a few questions that I'd like to ask for the benefit of the entire group.
Alright, sure, go ahead.
So these are questions that we've asked a couple of practitioners before.
Yeah.
Firstly, would you say that opting for arbitration early on and staying with arbitration for a significant amount of time, maybe 4 years, would preclude us from returning possibly to India, or possibly even if were in India to the practice of litigation?
I wouldn't say so. And the reason is that India is a country of generalists. Everybody does everything. Even the councils that you identify with a particular field of law do everything. Harish Salve also does criminal law, and Mr. Ram Jethmalani also did most of his work as a constitutional lawyer or civil lawyer. So it's a country of generalists. Gaining experience in one field of law, in my opinion, does not preclude you from the others. I think the best practices today are those of the people who are jack of all trades and master of one.
So there is merit in super specializing early on, you'd say?
Yes and no, both. If it is to the exclusion of everything else, then it is harmful to your career, because then as a counsel you can't think on multiple levels, because your client is only asking for relief. He really doesn't care how you get it. So you need to think at multiple levels at what is the best way to get that relief. But it's always best to have a specialization if it is not at the exclusion of your exposure to other fields of law.
My second question pertains to some of the experiences that you've had. What do you think the value of interning at an international firm, B under a prominent international arbitrator, C at a prominent institution are?
All of these broaden your horizons. When I interned with an international law firm or an arbitrator or did an LLM, it was like stepping out of a well. It is a horizon broadening experience. So it's the exposure more than anything, first. Second, you learn a lot of things. Professionalism, presentation, articulation, organization. All of these things, you realize that a lot of international firms, and again, international firm is a very generic term. It has to be a good place and things like that. But a lot of international firms, the premier ones, just do it so much better. They have institutional memory, which has experience of collective practitioners over years. The firm I had the fortune of working with had been around for over 130 years. So the collective institutional history of experience reflects in their working. Therefore, I personally suggest that you should try for these opportunities, and if you take the initiative, these opportunities, although not easy to land, but are accessible.
Any other questions?
Yes.
Just one. Yeah, just. So, what would you say is something that you can possibly do in law school that kind of helps you look at these horizons broadly, but like not limiting them? So, for instance, I think that when you moot, you kind of understand something pretty well, and then you think of it as the be-all and all. So, how would you prioritize stuff like mooting or academic research along with the stuff we study at law school? And what's the other thing or something else you could do to kind of understand what the practice is before you kind of get into it?
Well, I can't form a perfect hierarchy of the things you should do, but my personal experience, the thing I would put at top priority is partying with different people. Make friends, enjoy law school, because after law school, life is very different. And when you look back upon law school, a lot of your experiences will be identified with people rather than the things you've done or papers you've published or moots you've done. I did 6-7 moots during law school, but most of my memories from mooting are with people and the conversations I had and the initiatives we took together. Also, distinguishing yourself comes from initiatives. I must congratulate Nyaya is a wonderful thing. When I was graduating from law school, I started an initiative that keeps getting me so much goodwill that I never thought. People who know that initiative much more than they know me, the GLASS scholarship, which is the litigation assistant scholarship of GNLU. I was in my final year when I took the concept note to our director and we started that process. So many things like this, the initiatives you take would propel you in your career much more than anything. Publications. Now, people write off writing for blogs very much. I think Nalsar is a little different because a lot of very good homegrown blogs. But writing for blogs is, it's very useful. Okay, it helps you get into the habit of writing. So write for blogs, smaller places, magazines, and things like that. Just take every opportunity to write. That will really help you in your careers. Personally, I thought teaching helped me a lot. I started teaching at GNLU from my 3rd, 4th year, and since then I've been involved with teaching assignments in workshops and long credit courses with different universities. It personally helps me a lot. Start taking those student teaching assignments where you're helping your junior batches, even if it's not formal, if it's one night before the exams, helping your batchmates pass the exam, all of that will help you.
All right. Yeah, so I won't keep anyone else from dinner any longer. So anyone with questions, please take it outside. Thank you all for being here, and thank you, Garv, for coming down, spending time with us, and sharing your nuggets with us. I'm sure anyone else who has anything will reach you
let's
later.
not keep the others from dinner. We can take this outside.